Yeah. Right. Take it Tooblack back on it. Now I heard somebody say something about conditional acceptances. We've done the acceptances. Right. Okay, let's do this. Conditional acceptances. Alright, everything in commerce is commerce to start with. Number one. Everything is commerce nowadays. So there's no just is. If you're gonna call it just is, just for us. There is no just is, everything is commercial. That's why it's charges and services. Now, in commerce, you have 4 options when you receive an instrument in form of a letter, or a bill, or a statement, whatever you want to call it. Alright? 4 options. First one is acceptance. Acceptance for value. Acceptance for value means you're accepting the document for its value because there is no preceding contract or precedent contract. Okay, so you're going to accept it for value and you're going to discharge the charges using your exemption, your social security number, your national insurance number. You can discharge instruments using your birth certificate and bond numbers, right? This particular one, I believe, was to do with, what is it? A mortgage. So I'm gonna give you a sample of how to do a conditional acceptance. Because you have to do this. If you accept it conditionally and endorse it properly and give them the authority to discharge it, that's called acceptance. If you find an error in their instruments, you don't accept it. You conditionally accept it if they can correct the error, and then you're going to accept it after that. Those are the only 2 options you have. If you ignore it, or if you argue with them and cause a dispute and get taken to court, you're going to be in dishonor, you're going to lose the case. Alright, I think that's straightforward. So this is a sample of how you draft a conditional acceptance. First point I always put in, I make it private and confidential, because everything is private and is private. There is no public anymore, right? So all your so-called public corporations were sold into the private sector. Now everything is owned privately, so everything is private. So you're going to do it as that. So the private correspondence for a man or a woman, known as, you put their name there, who does business, by acting as, you put their capacity there, their role. So it could be a CFO, CEO, agent, whatever the capacity, solicitor, blah blah blah. I always put by use or by utilizing company registration number. We dig them up from company's house and find the numbers. The numbers are also available on the documentation. If it's a solicitor, this one looks like it was for a solicitor. Yeah, we get the number from the documentation also. And stick it in there so there's no mistake who you're dealing with. Then you get the date of issuing the notice. This one is a notice of conditional acceptance. Whenever you're going to do it, you put your dates in there. ABC. Look how easy this is. Little boys and little girls. Alright? The men and the women know what we're talking about. The little boys and little girls, pay close attention and take some notes. Don't imagine that you have such a good memory that you can just absorb these things and bring them forth when you feel like. You have to learn it. You can't copy and paste this stuff. I've seen some morons trying to copy and paste these things, taking 5 different documents, copying and pasting and putting in one document and sending it out to people. Because they're too lazy to do research and to learn how this thing works. So you need to get off your lazy ass and learn it. Copy and paste doesn't work. You need to know what you're writing in each particular document. Right. Conditional acceptance. The way we serve process is we use post office right now. But eventually we'll start using process servers. So we'll go to the venue, hire one of their people in their gray suit and get them to serve it. But post office is a recognized processed server. There's only 3 ways you can serve process. Number 1, using the post office. Special delivery, record it, get a number for it. Number 2, by using a process server from the court. So you go up there, say you wish to speak to a process server. Somebody shows up, you give them some money and your documents and tell them where to serve it. And after that, they're going to produce a certificate of service. And you can use that certificate of service as proof of service and delivery. All you need to do is prove that you've acted honorably in commerce, that you haven't ignored or argued with the claimant. So you put your process properly. Number 1, post office. Number 2, process server. Number 3, by hand. If you can achieve either one of those 3, service is effective. If it's done any other way, it's defective. Right. So you're going to say, greetings, Dick, whatever the name is. We, this was from the advocacy, so he says we. If you're writing on behalf of yourself, it's always good to use we because there's 3 of you. It's not one of you. You didn't know that. Because in our training of children, we're told that there's 1 of us, but there's 3 of us, really. Your mind, body, and soul. So we, the mind, body, and soul, no, sorry, this is for the advocacy. Or you can use I, if you want to put it in 1. So I, whatever, where are we? So we act on behalf of the tenant. So this was, I remember this one. Possession order. So they've sent the tenant a possession order saying, okay, we had a court hearing on this day, and the court determined that the bank should take possession. So the solicitors are writing to the homeowner asking them to piss off on a certain day, right? So we act. So the advocacy wrote to them and said, we act on behalf of the tenant of the property known as, and they put their location there and there, blah blah blah, and we here acknowledge receipt of your correspondence. So that's their paper instrument, their item, commercial instrument. Oh, this was inviting participation in a purported claim at the court. So this was, come over for a hearing, a possession hearing. Okay, so we wrote to say that we represent the client, the tenant, and this is his position. So the tenant of the above property has an agreement with the proprietor where the tenant is an obligation in respect of making any due payments and settling all accounts thereof, as concerning the property. Right? Now, the tenant has instructed us, the advocacy, to make full payment, giving you remedy within 72 hours, right? So you don't need to go to court. We're going to pay you within 72 hours of receipt of the documentation that we request below, right? And the tenant also requires that we gain private settlement of the matter in its entirety, thus conferring no subject matter jurisdiction upon any civil court whatsoever. Okay, so what the court is trying to do is to gain subject matter jurisdiction. As soon as they do that, they can rule. The trick is to serve you a paperwork using a defective service of process, and if you're dumb enough to attach to it, boom, subject matter jurisdiction is gained. Okay, so what we're saying to the solicitors for the bank is now, oh, hang on a second, we are the advocates for the tenant. The tenant does not wish for controversy. The tenant wishes to settle immediately, more or less. So this is how you construct your conditional acceptances. You have to have 4 headings. Heading number 1, notice of conditional acceptance. Heading number 2, statement of facts. Heading number 3, memorandum of law. Heading number 4, notice of fault and counteroffer. That's it. If you don't have those headings, it's not a conditional acceptance. You don't have to head them up like that. You can draft it, format it whichever way you want, but those terms need to be there to make it a conditional acceptance. Right, so what do you conditional accept? I always put notification applies on principal and his agents equally. So we, on behalf of the tenant, make conditional acceptance of your offer to come to your hearing, to settle the claim, and confirm our willingness and ability to settle this matter forthwith upon our receipt within 10 days of number 1, how much money do they want? So written confirmation of the exact final amount that you allege is the balance owing on this mortgage account, right? 4 things only. We don't ask for much. Number 2 is a certified copy of the letter of authority, because these are solicitors, right? So presumably the bank must have written a letter of authority and given it to him to act on its behalf, because the bank claims to be the true claimant. So we'd like to see a certified copy of the letter of authority. If they don't have it, they're making false representations, because they don't have a power of authority to act on behalf of the claimant, because the claimant has subrogated the loan and sold it. So the claimant cannot appoint anyone to make a claim on their behalf. I hope you get to seeing how the trick is being done. So that's all you need to see. The third one is a certified copy of the note that the client, the bank, alleges is at fault and is the cause for bringing the claim. So there must be a note somewhere that hasn't been paid. And finally, we need to see the full name and contact details of the holder or holder in due course of the note, or any other party who claims that they've incurred loss, injury, or damage as a result of the note being at fault. Simply means who has suffered any financial loss because you haven't paid your mortgage. So let's see who. We need the full name and their contact details. So that's your conditions. They're very plain, so you restricted all the issues to 4 matters only. So there is no controversy, there's no argument. I'm going to pay you within 72 hours. As soon as I receive these 4 things, how much money is owed, your letter that you're the guy to pay, so I don't pay the wrong guy, right? And whoever it is that's suffered damage, I'd like to make them whole again. So there you go. Now, plain statement of facts. This is a short, I'm going to show you 2 versions. This is a short version. This is straight to the point. I have longer versions. It depends on what kind of case you're dealing with. But this is a short version of a conditional acceptance. So we're going to do the short version, then I'm going to do a longer version. Right, so plain statement of facts. The tenant is a private soul with neither the knowledge, interest, nor the wish for taking part in a public controversy. So you're never going to see me in your public courts, because I'm a private soul. I don't participate in public BS. Okay? The tenant is without prior knowledge of any valid claim against the said property. So if you're the tenant and your landlord hasn't paid the mortgage and you pay the landlord on a regular basis, they cannot evict you. On that, you have an agreement with the landlord, so it's private. You're not going to be using a public court to resolve a private issue. Right? So you have as long as you have no knowledge of the claim, you cannot answer anything to do with the claim. That's the point. You have no knowledge of the nature and cause of them wanting to have a hearing to do this property, right? And then the third one is that you're in receipt of no service or effective service of any legal process concerning the property. So if they say they send you letters, ask them for, oh, please send me a certified copy of the certificate of service to show how you served me process before, to say that you have a claim or you express an interest in my property. You dick. How stupid can you be? Right? And the tenant is, finally, intent on enabling prompt settlement without need for any court proceedings. That is where your stand is. Once you make the stand that you're willing to settle without court, end of story, they have no recourse to a court. Why would you go to court? They produce the paperwork, you pay them, and end of story. They don't produce the paperwork, they're at fault. and to give them a certificate of fault. That's how you do business. Right, the law that you're going to use, or is used for this particular claim, or answering the bullshit claim was, we use maxims of law, not statutes. Use maxims which were there before statutes. So no action arises out of an immoral consideration. He who mistakes is not considered to be consenting. The reason I choose these particular ones is no action arises out of an immoral consideration, because they're claiming that this is contract law, that you breach terms of a contract, but there is no consideration in this contract. What's their input? What value have they added to it? So how can they bring an action where they haven't added any value? Now, he who mistakes is not considered as consenting. You did a mistake when you signed an agreement with yourself, to call the mortgage agreement. You didn't know that they were going to sell it. If they told you that they were going to sell it and how much money they were going to make out of it, you might have not signed it, or you would have sought a different agreement. Oh, my battery is running low. Oh, shit. And finally, it's not the fault and counteroffer. So that's what it is. The battery is going to shut down, so I hope you can see that. So if they don't respond with